Hello, 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 everyone. Good evening, guys. Do you hear me loud and clear? Microphone check 1 2. What is this? Can you please put a 1 in the chat or thumbs up if you can hear me loud and clear? I don't want to be screaming either. I don't like screaming. I hate that. Okay, something's going on. I don't know what's going on here. Hello? Can anybody hear me? Okay, there you go. I might be getting a slow reaction. Hello, everyone. Hello. Welcome back, guys. Welcome back. And we got our girl, Miss Esquire, is in the building. We are going to talk about all the confusion that's going on with the Rkelly case and the motions that were put in. Can you please give me a second? Felicia, say hello to everyone.
Hello, everyone. I am so glad to be back with you all. Hello to everyone in the chat. Hello to the OCOV fam. I'm glad to be back, and hopefully we get to have some really, really good conversations tonight about some of the law, because this trial is kind of turning the bend. It's coming towards the end. So I'm really interested to see what I could clear up for everyone and see what everyone's thinking about the trial thus far. Oh, and shout out to Henny Hen. Henny Hen says, I'm a Kel supporter, but I don't come with any disrespect. Hi to Diva and hi to Felicia. Hello to you as well, Henny Hen. You're free to think whatever it is you choose to think, as long as you do so respectfully. And again, hello to the OCOV fam.
Sorry about that. I had to step off the camera for a moment. Yes, so we got our girl in the building. Hello. Everybody, we're going to be talking about the motions that were put in just recently by the defense team, talking about the statue and the bribery and what that really was all about. So we're going to have our girl here. She's going to help us out. And guys, please make sure you hit that like button on your way in. Thank you. And I'm going to pin, give me a second. I'm going to pin my comment there. My son is tripping out, y'all. So I might have to go off the screen every so often, okay? Just to let you know. The boy wants to act up. He doesn't want to go to school. You know, things of this nature. All right, so I pinned up my Cash App and Miss Esquire's Cash App. If you guys would like to donate, donations are welcome. And they are greatly appreciated. So, Miss Esquire, what do you think about this case so far?
Well, this has been a riveting trial, to say the least. There has been so much information that we've learned, that we've heard from the testimony in this trial, that is just absolutely mind-blowing. I mean, at one point, I was discussing this trial with someone, and I was telling them the testimony of John Doe #1, and I'm literally mid-sentence, and the person stops me, and they go, "No, this isn't. This happened. This is real." So we a lot of things that just, it sounds like it's a book. It sounds like a story. It's crazy, some of the things that we've heard. And my heart really goes out to all of the victims that testified, that had to relive a lot of these things. Because the bottom line is, whether you feel personally that Rkelly did this or not, you have to acknowledge that these people were clearly traumatized by something. You know, you could tell from their testimony that something happened to them, and it's terrible that they had to relive that.
That's right. And, you know, a lot of these Rkelly supporters just continue to re-victimize them on top of the court process.
Mm-hmm.
Going on the stand, you do get somewhat re-victimized because you have to live the trauma, you have to remember the dates, you have to remember what you were wearing, or things of that nature, just things that trigger you. And I think that that new guy that just testified for the defense, I think he might have been a John Doe, honestly. What do you guys think? He said he was with him since he was like 19 for like 15 years. He worked for him, but he didn't pay him. Like, what? And then what was his name? Danny? And then he wanted to play his song that him and R. Kelly apparently did together. And he wanted to let R. Kelly know that no matter what, he'll always be his mentor. And he told him that he was there to learn and be somebody. Like, just like what he did to Azriel. Like, that's bananas. That is bananas. I honestly think he's another John Doe. I don't know. But
I think that's possible, and we'll never know, I guess, at this point. We'll have
at
to
this
see.
point, we won't.
Yeah, we'll have to see how this trial turns out. I think it's totally possible, and I've been hearing some murmurings about this nutritionist. Are you familiar with nutritionist Diva? What's her story?
Yeah. Over here, we call her, she's the flower pot lady. She's the flower girl. She's his nutritionist. She was allegedly screwing him, and allegedly she even got inseminated by him, and there was a bun in the oven, and then he found out or whatever. She told him, and then he fired her. And allegedly, there's pictures of her floating around in possession that this man or other people have of her. There's a lot of things. She's gung ho for R. Kelly. She likes to intimidate witnesses and things of this nature. She goes after the R. Kelly supporter, bloggers, anybody that just doesn't, agree with R. Kelly. But yet she just had an interview on Court TV. She just had an interview on Tasha K. And she's all over the place. She even had an interview with Toxic Diamond as well, and other people on some social media platforms out here on YouTube.
Interesting. I wondered because when I heard about her, I heard that she is a supporter of R. Kelly. And so my question for the person who was telling me about her was, well, does she think that he's innocent? Because it's one thing to say that you support someone, but it's another thing to say that you think that he's innocent. So I said, I'm wondering, does she think he's innocent? And the person that was telling me about her, they said, yes, she says that she was close to him and she was around and she would have known if something was going on. And she says that he's totally innocent. And so I said to the person, I said, has she heard this trial at all? Is she missing some type of, do her ears work? Has she heard this trial at all? And if she's heard this trial, does she still think that he is completely innocent of all charges? And the person told me that yes, she's heard the trial and they think that she is maintaining that he's absolutely innocent of everything.
Yes, she thinks he's absolutely innocent of everything. She says yes, he slept with many women, he likes to have sex, he's addicted to sex. Yes, he likes S&M, this and that and all these things, but he's innocent of all charges because he doesn't run an enterprise. He didn't use his business to lure in girls and things of that nature. He just liked to have sex, and there's no crime in sex and rock and roll.
Okay, all right, well, that's interesting. I was also told that part of what she has said is that there was no crime because the women that he had intercourse with were all over the age of 18. And I then said to the person, does she understand that under the Mann Act, it doesn't matter if someone is over the age of 18. It is still illegal to transport them for the purpose of selling them for sex.
Thank you. Illegal sex. Now, I had asked a supporter, what is illegal sex? She couldn't even answer me. Hold on one second.
All right, so I'll take this time to give a little shout out to Take Rkelly. How are you doing, Take Rkelly? Nice to see you. Hi to Karen J as well. Just giving a little shout out to some people that I recognize from over on my side of the pond on Empowered Esquire TV. Nettie
Yes,
Boo.
yes. I'm sorry about that, guys. Yes, shout out to everybody. Yes, shout out to them. Shout them out. What's up, OCOB? We are in the building and everybody else in the background peeking in the window. Hello, guys. Hello, hello, hello to all my brothers and sisters, my family, my friends, and my supporters. What's going on? I wanted to say hi to everyone as well. And I love the fact that my people over there and they got your back, girl.
Yes, they are definitely through. They come through in my lives and they're supportive and awesome. And yeah, for real, they're good people.
We love you. We love you, Miss Esquire. We love you. We love your knowledge. We love your empowerment. We love your professionalism. We just love you.
And I love you back.
All right. So I see that Mr. Non-Lawyer is in here. What's up, Non-Lawyer? Listen, I'll drop the StreamYard after, okay? Then you can come in with whatever questions, all right? Henny Hen said, okay, let's see. Can I ask questions without being disrespected and just for an unbiased answer? Yes, please, guys, listen, my mods, I don't mind anyone coming in with questions. Let's not just assume that every question that comes from a supporter is a dumb question or a disrespectful question. Can we just let them get their questions so they can learn too? Okay? If they get disrespectful, we know what disrespectful is, right? If they're attacking someone, then we block them. If they're not attacking someone and they're just simply asking a question, there's no right or wrong questions. Okay? Thank you, guys. Just don't be disrespectful. I don't mind questions. We here for it. We are here for it. It's called discussion, open dialogue, free for all. Okay? All right. And don't forget to hit that like button, even those in the bushes. Okay? Y'all might not like me, but like the commentary. Thank you. Miss Felicia, do you have anything to say on that?
No, I do not. Eva, you got it under control.
All right, sis. I just wanted to make sure if you had something to say, let them know. You know what I mean? Over here, we're very relaxed. You could be you, baby. So, okay, now we're going to get into, let me share my screen. Which one were we going to talk about first? We were going to talk about, is this it right here? Hold on. I hope this is the right screen. Oh, yeah, okay. Which one was the one that was entered first? I forgot. It was the defense that put it in first, right? And then the government responded? Yeah. Okay. Is this the correct paperwork, Miss Esquire? Do you see my screen?
I can see your screen, and I believe that is the one that has to do with bribery. So yes, I think that's the one you wanted to discuss first.
Yes. Okay. The one that came from Mr. Scholar. Okay. I'm trying to make it as big as I can, guys. I don't know what's going on here. Hold on. We have to hide this. Oh, yeah. Okay, guys. I want to know if you can see the screen. Can you guys see the words? I want to make sure y'all can see it. Okay. So now we know that on September 18th, right, the defense, Rkelly's team, put in a letter of motion to Judge Donnelly, and they were stating that they submitted this letter seeking an amendment. An amendment means to change or correct. Is that right, Ms. Esquire?
Correct. So the way that the jury instruction process works is it's teamwork between the judge and both attorneys. So the judge will provide to both attorneys a kind of proposed jury instruction. So kind of what the judge thinks would be appropriate. And then each attorney can submit amendments. They can say, well, Your Honor, can we change this? Can we tweak that? Your Honor, could we add this or add that? And then at the end, you have jury instructions that are kind of comprehensive for the purpose of making them unbiased.
Thank you for that. And so then it continues to say that they wanted to amend the proposed jury instructions, and that the defense recognized that the court directed the parties to submit joint proposed instructions, just as Ms. Esquire explained right now. However, after a review of the testimony elicited at trial, the defense submits that the proposed amendments are required. Now, that means because of the testimony due to Demetrius Smith and what he said at the trial, right? I explained that to you guys last time when I read it, that due to what he said in his testimony, they want to change the jury question or remove it. Am I right, Ms. Esquire?
Right. So they actually, from what I saw, they want to tweak it. They want to kind of have the instructions more closely mirror the statute in Illinois.
Right. So in other words, they're saying, why is this in this state when it should be in Illinois? Because what happened was in Illinois. Am I correct?
Right. So they're pretty much just saying the jury should be given instructions that are closer to the law in the state of Illinois because that's where this happened. And then they also go on to explain some other things that, we'll discuss when you get there.
Okay. Then, so they're requesting number 16, which is the Racketeering Act 1, and it is with respect to the Illinois statute for bribery. As she explained now, it's due to the statute in Illinois. That's their law. Then it says the proposed instruction currently reads, let me get this down. Okay. It says that the Illinois Criminal Code section, my computer's acting up, 5/33-1A provides an pertinent part that a person commits bribery when with intent to influence the performance of any act related to the employment and function of any public officer or public employee, he promises or tenders that person any property which he is not authorized by law to accept. Now, what does that mean, Ms. Esquire, if you can break that down, that legalese stuff?
So, in layman's terms, it is bribery when a person approaches a public employee or some sort of public officer and offers them either money or property for them to do something within their capacity as an employee or an officer. So, for example, if individual A approaches corrections officer A and says, hey, officer, I'm going to give you $5,000 for you to move, my friend from cell block B to cell block D, right? So you have someone approaching someone in their capacity as some sort of official employee or representative or officer, and then offering them money for them to do something in their profession that without that incentive, they are not supposed to be doing. And also that they are receiving an incentive that it is illegal for them to receive.
Okay. So in the testimony of Demetrius Smith, he alleges that Rkelly was not present when the exchange happened with the money, and that he didn't know of the plan exactly. He knew what was going to happen, but he wasn't there to come up with the plan. He wasn't the one who came up with the plan. It was Daryl McDavid and Demetrius Smith. They were the ones who came up with the plan to go bribe the officer. And what's his name? Daryl McDavid was the one who paid the money to Demetrius to go get the ID from the officer. And it wasn't Rkelly's doing at all. So that's why they came back with this motion. What do you think about that?
Precisely. The reason that the defense, more than likely, we should say, probably, the reason that the defense came back with this request for the instructions to be tweaked is because they want the jury to kind of get this hint of, well, bribery should be a direct exchange. And the testimony that you've heard from Demetrius Smith does not sufficiently connect Rkelly to the money that was exchanged for you to prove that Rkelly really was the person that committed bribery. So yes, they want these instructions tweaked because they are trying to insinuate that really it was Demetrius Smith who bribed someone and not Rkelly.
Right, right. So that's the whole gist of that. Right now, I had read this the other day to everyone when it came out. Okay, so boom. Now, here is supposedly, it says the term tender means any delivery or proffer made with the requisite intent. As she said, exchange, with the intent to bribe the person. Now, this here says instructions and note approved January 26, 2018. Now, is this here the 720 Illinois, I forgot what that stands for again. Ugh. CS 533-1. This is the statute, right? This is the law.
Right. That's the law.
So is this the law that they're stating that they should go by?
Not necessarily. So I think they're just providing the law that's applicable in Illinois. And then on that next page where you see they begin with therefore, I think that's where they get into how they think the instructions should be tweaked to match the law that's applicable.
Okay, so right. Now that law is the law that they're describing.
Yes, they are saying that that is the appropriate law, but they're saying that the current instructions need to be tweaked to mirror the law more.
Okay. So it says, therefore, according to the Illinois pattern jury instructions, the person charged pursuant to the statute has to either promise or tender property or promise or tender property to another person with the intent to cause the other person to influence the performance of official act. This is further illustrated by additional guidance provided by the Illinois pattern jury instructions. And then it gives the example of the criminal law pattern jury instruction criminal 21-12. .12. So that's 21 section 12, right? Chapter 21 section 12, correct?
Correct.
Okay. So in that chapter, it talks about issues in bribery for the official, right? Or does it mean official bribery? How does that, Is that what that
Let me
means?
let me take a look at my copy that I can see really, really well. So let's see.
Please do,
Okay,
ma'am.
so issues in bribery official. So I think what they're talking about is what kind of person qualifies as someone that you can bribe, right? Because you can't
Ah,
bribe the ice cream man, right? So
right.
I think that's what they're getting into. So they specify, that it should be a public officer or a public employee, right? And then they further specify that the defendant should promise something to this public officer or this
Right.
public employee.
Which was the $500, right?
Right. And then third, they say, and the defendant has to do so. So the defendant has to make this promise to this public officer or public employee
Right.
with the intent to influence them, like I said, within their job. So within their public function, the defendant has to intend to influence them to do something within their public function.
Okay. So, what do you think about this issue and the defense coming up with this change? Do you think they are correct in doing this?
Well, I'm not going to say they're correct or incorrect. And the reason why I say that is because it's their job to try everything, right? You kind
Right.
of like you throw things at the wall and you see what sticks. Right. I mean, that's really their job.
Right. Right.
So I won't say agree or disagree, but will I say that I think this jury instruction is needed? No. I think they're obviously trying to insert the idea that Demetrius Smith did this on his own and R. Kelly had nothing to do with it. And I think that's taking it a step too far for jury instructions. I think you
Mm,
give the jury the law, you make sure the jury understands the law, and then you allow them to come to the conclusion that they come to. It is supposed to be the role of the jury to decide whether or not they believe Demetrius Smith, right? So the jury is supposed to decide, do I believe that Demetrius Smith did this on his own? Or do I believe that he did it because R. Kelly asked him to? But I
right.
think that the defense counsel here is really trying to insert their ideas into the jury's mind.
Okay. Okay. And now it says that at the instant trial, the government called Demetrius Smith regarding the bribery charge. On direct, Mr. Smith testified that he alone offered money to another person, that Mr. Kelly was not present when he discussed anything about money, and that he received the money from another person and not Mr. Kelly. And then it says trial, the transcripts, pages 714 through 719. On cross-examination, Mr. Smith was asked the question, okay, now, Robert never had anything to do with you bribing anyone to get a marriage license. Am I correct? And then he answered, no, he didn't. So, do you think that the bribery charge in this RICO should be dismissed, Miss Esquire?
I do not think so. I think the charge should be submitted to the jury for the jury to decide, because the jury has the role of what is called in the law fact finding. The
Mm,
jury is the fact finder, and they
mm,
are supposed to weigh the credibility, meaning they are supposed to decide if somebody is credible or not, believable or not. So I
okay,
think it should be submitted to the jury, and the jury should decide, well, do they believe that Demetrius Smith did this on his own, or do they believe that R. Kelly was involved? I think the jury should be allowed to make that decision. I definitely do not think that it should be dismissed. And I say that because even though Demetrius Smith is alleging that R. Kelly didn't know anything about him bribing this person to get this marriage license, we saw
right.
evidence contrary to that. We saw evidence that obtaining the license and marrying Aaliyah was discussed with Demetrius Smith. We saw
That's right.
evidence that Demetrius Smith was given access to money, whether it was through
Yes,
somebody else or not, right? So
right.
I think the charge should be submitted to the jury, and the jury should decide what they believe.
Yeah, well, that's why Auntie Anne was not dismissing this. The other side was saying that Judge Donnelly dismissed this. Now, it says that the count related to the bribery should be dismissed. So if the court, however, decides to submit the charge to the jury, it is clear that the government's theory is that the bribery was conducted through an intermediary. So no matter what, whether it was through Rkelly, if he did it himself or not, somebody else did it for him, and basically that's what counts, right?
We are going to have to see what the jury thinks about, about Demetrius Smith and his testimony.
Right. So now in this intermediary, it says that to sustain the charge of bribery, the state must prove the following things. The first thing is that the defendant promised or tendered. The second thing is that the defendant did so with the intent to cause, to influence any of the related acts to the employment, the function, the public officer, or the employee, or the jury, or witness, for examples. So if you find from your consideration of all the evidence that each one of these propositions has been proved beyond a reasonable doubt, you should find the defendant guilty. So that's one of the questions on the instructions, right? That's one of the instructions, part of the instructions. And then the other one says, if you find from your consideration of all the evidence that any of these propositions has not been proved beyond a reasonable doubt, you should find the defendant not guilty. Over here, we find him guilty. Okay? Okay. So now, then it says that the second part of the proposed instruction in the case currently reads that the defendant caused another person to promise, to tender, No matter what, it doesn't matter. For those of you who are over there spewing all these things, it just doesn't matter. He knew what was going to happen. He knew what was going on, and they all did it on the behalf of Rkelly. The enterprise was working for him. Period. Am I right, Ms. Esquire?
Well, from the evidence we've seen thus far, now what I will say about this second portion of the jury instructions, could you go back to it just really briefly?
Yes, ma'am.
It pretty much says exactly what Diva and I have been saying. So the defense says that the second part of the proposed jury instruction says the defendant caused another person to promise or tender property. So in other words, the proposed jury instructions had a portion in there which said, if Rkelly got someone else to give the money, he committed bribery. His defense counsel is now saying, no, it's not fair to say that because the statute does not say that. So again, defense counsel for Rkelly is arguing that the statute says the person has to exchange the money or whatever it is themselves.
Right.
They're saying that the government is interpreting that Rkelly can bribe through someone else, but the statute doesn't say that. And they want the instructions changed to say that Rkelly would have had to bribe this person directly himself.
Wow. So, and in the RICO, right, someone had said, Corey Simmons had a question. He didn't know, he said, a statement, shall I say. He didn't know what was going on, and it wasn't an enterprise. Can you answer that?
Well, anyone can claim that Rkelly didn't know what was going on and that it wasn't an enterprise. Anybody can just claim that. But what we've seen throughout this trial is phone calls, text messages, rules, directions. We've seen everything that would lead anyone to think that Rkelly was aware of everything that was going on and that, in fact, most of what was happening was being done at his behest. So, anyone can say that they don't think so, But we've seen a lot of evidence, I would say, in my humble opinion, that has established that, pretty much everyone that was operating within this entire situation was doing things at the request of R. Kelly.
Right. So therefore, R. Kelly was running an enterprise because he is the head, the CEO, and everything went under his direction. Even though people in his camp were underhanding him, everybody was still moving because of him. People were stealing for him. People were doing this. People were doing that because he had so much control. And remember, he used to dock people's pays and things of that nature. So yeah, people were getting their money back one way or another. And that's just my humble opinion. So,
so Sidbo says,
I was about to say that. Go ahead.
You want to read the comment then?
No, go ahead.
Sidbo says, I'm running a restaurant, and if one of my employees slaps a customer, whose responsibility is it?
Right.
Exactly. So technically, right, Sidbo, maybe he didn't tell that person to go and slap this person, right? But he's still to some extent responsible. So when you take that and you apply that to R. Kelly gave people, I guess you could say, outcomes, right? So for example, if R. Kelly says to Demetria Smith, I want to marry Aaliyah, right? Both him and Demetria Smith understand that Aaliyah cannot legally marry him, right?
Right.
So now if Demetria Smith then proceeds to do things in furtherance of R. Kelly marrying Aaliyah, then who can we say is really the reason for all of the actions that took place? Is it R. Kelly is the reason because he set the ball in motion by telling his whole gang of people that he wants to marry her?
Right.
Or are we going to say that no, Demetria Smith is the person who's responsible because he chose to go out and do those things? Ultimately, the jury is going to make that decision. But of course, the government is arguing that there was an understanding between all these people that when R. Kelly gave you a directive for something he wanted to happen, you were supposed to do whatever it takes to make it happen.
There you go. There you go. You said that beautifully. I could not have said that better. That's the point. That is the point. That is the whole point of an enterprise. And he ran the ship. Sole proprietor. He is solely responsible for everyone under him. That's what a lot of you supporters are not understanding. Please understand that. That is why they brought this case the way they did. That's why they made it a RICO, because they know that all these crimes were way back when, and is way past. And they had to figure it out. They said, you know what? He's been running this shit like this, like that. Look at all these patterns. This to me looks like he was running an enterprise to try to lure young ladies in to do illegal sexual acts with them for his own gratification. Not even that he was pimping them out to other people, but allegedly, come to find out within the documents and the transcripts that we've been reading lately, he did that as well. He even paid people to have sex with the other girls. He even punished other people to have sex with the girls as a punishment. So if that's not a racketeering, I don't know what is a rakatakata, but that sounds like a rakatakata to me, okay? So what do you think, Ms. Esquire?
I'm sitting over here muting myself because I'm laughing at you saying rakatakata.
Okay? Because that's what it is, girl. It's a whole racket, okay? Rakatakata, okay? There's a whole song out there in a reggaeton world, rakata, okay? Yes, if you hear it, you will jam to it.
Yeah, I actually know that song, but that funny that's not what I
Okay.
thought of. I just laughed so hard when I heard you saying that. But I mean, really, it that is the definition of an enterprise. But that is
Right.
why these cases are more complicated, right? Because you have to explain that to a layperson. You have to get a juror to understand that when you have someone running an enterprise and they give somebody an outcome, all
Right.
the things that happen along the way to get that outcome, the head of the enterprise should be responsible for.
That's right. And the head of the enterprise is who, guys? Hashtag Art Smelly. Okay. That's who is responsible and is needs to be an account. Okay. He needs to be accountable for these things because he convinced and coerced his own employees to commit criminal acts. You understand? That's what it is, man. Y'all gotta understand that. I don't know what you guys, you supporters are out there seeing. I'm very confused as to what you see because I don't see what you see. I see that the prosecution did exactly what they were supposed to do to prove their case. And I think they proved their case very, very well. Now, the defense needs to just sit and wait for that sentencing. Amen. And that's, allegedly. Now, the second part of this letter that Mr. Scholar put in was talking about the California Health and Safety Code. And that had to do with the whole herpes situation. The herpes, herpes, herpes. Lord, we can't get enough of herpes over here. So then it says, with respect to the California Health and Safety Code, the proposed instruction currently reads that the government must prove beyond a reasonable doubt that first, that the defendant knew that he was afflicted with any contagious, infectious, or communicable disease. Two, that the defendant exposed himself to Jane Doe number 5, amongst others, I'm just adding that, by engaging in unprotected sexual activity with Jane Doe number 5. Third, that the defendant acted willfully. And fourth, that the defendant did not inform Jane Doe number 5 that he had a contagious, infectious, or communicable disease and obtain her consent to expose himself in these circumstances prior to engaging in the exposure. So, let's think about that, guys, right? Do you guys put it in the chat? Do you guys think that the government proved beyond a reasonable doubt that R. Kelly willfully exposed himself, unprotected sex, and gave these diseases because he knew he had them, and he just said, I'm going to do what I want to do because I'm R. Kelly and I use Valtrex. I'll be all right. And so will she. I need to have sex. So, Miss Esquire, what do you think about this defense motion and what they were trying to say? Please explain to us the real deal.
Well, they haven't. We haven't gotten to the portion yet where we discuss what they wanted changed.
Right.
We've only gotten to the portion where we talk about what the proposed instruction was,
What the
and
instruction
I
was.
think, yeah, and I think the proposed instruction was on point. Right, first, the defendant has to know that he has some sort of STI or disease. Second, he has to engage in some activity with someone else that he knows they could get that disease.
Right.
Third, he has to have wanted to do that, right? So the person didn't rape him or force him to do that.
Right.
And then fourth, he has to have done all these things without telling the person, hey, by the way, I have such and such, you know.
Right.
So these instructions sound like they're pretty much on point to me. So I'm interested to see what they want tweaked.
Right. So let's get to that part. But then here it says, however, the text of the statute actually provides. It basically says the same thing, longer terms. Right?
Right. So they go into the actual text of the statute, which I'm sure they're doing because they're going to get to the portion.
Right.
Right. As they did here.
Right.
Where
right here is where we should start.
Right. So where the paragraph starts with further.
Right.
It looks like that's really the meat and potatoes of it.
Okay. So now it says that further, the defense respectfully requests that the court provide an instruction that the defendant does not act with the intent required pursuant to the statute if the defendant takes or attempts to take practical means to prevent transmission. The defense also respectfully requests that the court provide an instruction that failure to take practical means to prevent transmission alone is insufficient to prove the intent to transmit a communicable disease. That is just, I cannot. Explain that, please.
Bazinga. So his defense counsel are trying to earn their paycheck. They're trying to earn their check. I have to give them that.
I read this and I was like, what is this?
This is creative. This is really creative. Kudos to them. So what they're saying, this is their argument. Their argument is that Rkelly did not intend to transmit herpes. He didn't have the intent. So they're not arguing that he doesn't have herpes.
Right.
They're not arguing that he didn't know that he had herpes, right? They are arguing that he did not intend to give the herpes to anyone because he took practical means to prevent his partners from getting herpes. Now, whether they mean condoms or they mean medication, I don't know what they mean. But that's their argument. Their argument is that Rkelly doesn't meet the requirements of the statute because he did not have the intent to give anyone the disease that he had.
Now, this is my theory of why they threw this in there like that. Because he probably was like, well, listen, I've been taking Valtrex since 1997 and I'm supposed to be good. So therefore, they should not have gotten the herpes from me because I've been medicated since way back in my way. I think that's why they try to throw that in there. What do you think of my little theory?
No, that really could be. I mean, you laugh, but you could be right.
Okay.
Their theory really could be that because he's taking Valtrex, he has made his herpes non-communicable, which shows that he is taking efforts to prevent other people from getting it, so he doesn't have the intent of giving it to anyone else.
That's why they should.
The argument.
That's why they should have threw his behind on the stand. Okay? That's what I think. They should have threw him on the stand, regardless. Because he's such a good manipulator. I'm pretty sure he could have had the jurors on their feet dancing to his songs at the end of the testimony. Just like a Boondock episode.
I was going to say what happened in the Boondocks episode. In the ridiculous episode.
Yeah, it would have been a whole deja vu. Okay? That's okay, so then, so that whole paragraph was a joke to me. I read that and I was like, Lord, but like you said, Miss Esquire, they're doing the job. They're doing their job. Okay, right. So now this is explaining the law, right?
Right. So now this portion, they go into the statute and they tell you what the statute says unlawful intercourse is.
Right. For those who don't know, unlawful also means illegal. Okay. So Unlawful sexual intercourse is an act of sexual intercourse accomplished with a person who is not the spouse of the perpetrator. If the person is a minor, for the purpose of this section, a minor is a person under the age of 18 years, and an adult is a person who is at least 18 years of age. So a minor is under 18, an adult is over 18. Then it says, any person who engages in an act of unlawful sexual intercourse with a minor who is not more than 3 years older. Wow, and federal is 3 years. I didn't know that because the state is 5. Now, any person who engages in an act of unlawful sexual intercourse with a minor who is not more than 3 years older or 3 years younger than the perpetrator is guilty of a misdemeanor. Now, that bothered me to hear misdemeanor, Miss Esquire. I was very confused by this word.
Well, it sounds like the law in California is that it is only a misdemeanor to engage in unlawful intercourse with someone who is a minor if the age difference is within a 3-year range. So, for example, an 18-year-old with a 15-year-old.
All right, that's a misdemeanor. Okay, all right. Oof, okay.
That would be a
Thank
misdemeanor.
you for clearing that up for me. Thank you. Because I was very upset by this for a moment. Like when I first read it, I was like, "Oh no, this just doesn't sound right. California ain't right." But then yes, now you think about it. Okay, yeah, okay. Whew.
Yeah, it's just to kind of provide, I guess, some sort of cushion for, the teenage love story.
Right, teenagers,
right. The whole 16-year-old with a 19-year-old, like that whole thing, which for the record, I, as an 18 or 19-year-old, was not interested in any 15, 16, 17-year-old.
Exactly.
But apparently, there are some 18 and 19-year-olds out there who are romantically interested in 15-year-olds. I don't know. Yes. I still personally think that is odd. But okay.
Right. I'm very bothered by that. But
I mean, at 19, I'm dating people who are in their 20s. I'm not dating somebody who's 15 or 16.
Right. When I was 16, I wasn't dating nobody that was 14, 15 or nothing like that. I was dating boys that were in their 20s, like 20, 21. I mean, I was 16. I even went with a 26-year-old man. My mom knew about it and everything. She consented to the relationship. You understand? Like, she knew I was already having sex because I told her that at the age of 13, I lost my virginity, even though I lied and didn't tell her that I was abused. But I tried to give her hints. There was so many things that I did with my mom that I tried to give her hints, and it was really hard for me to just tell her the things I went through. I just couldn't. So I kind of smoothed them into my life with her, to kind of open up the communication and, see if I can eventually get there. And you know what? It took me 31 years, well, at the age of 31, for me to finally say what happened to me. So it's very hard for people to come out with abuse, whether it be as a child or whether it be as an adult or as a teenager, just, as a person, period, who gets abused. It's hard for someone to talk about it. And it takes a while for someone to even open up about it. And it takes even longer to forget about it. Sometimes you just never forget. Some people do block it out. Some people have that gift. Some people have that power. They will never remember again. But then you always have it in the back of your mind. So, enough of that. Sorry about that. Boom. So, now we basically know what's illegal sex, right? Okay. Now, Oh Lord, Miss Esquire, when I read this part, girl, I fell out of my seat.
Yeah, I
Because
know.
let me tell you where this mistake of fact, okay? Let me explain you what why I fell out my seat. There's a blogger out here, right? Who's so die hard, I know she gonna faint. She gonna faint at the courthouse when she finds out he guilty. Listen, she decided to the judge. I saw this, and I said, "Oh my God!" His lawyers took a YouTube defense, okay? Because this one blogger started talking about the mistake of facts, right? The mistake of the age and this, that, and the third. So I cannot believe that they are actually are they actually trying to use this defense? Did they really try to use this defense in this?
So it appears that they are really trying to use this defense. Now, here's what I will say. We're probably going to get into this a little bit more after this, but it could be possible that California needs to tweak their statute. So, for those of you who have been over on Empowered Esquire TV with me, you've seen that there's some similar charges going on with a man named Michael Nowak, aka Brother Polite, right?
Right.
He's being charged in the state of Florida for unlawful contact and conduct with a minor. However, the statute in the state of Florida is very clear on this whole mistake of fact thing.
Oh.
The Florida statute says in the statute, this is a strict liability statute. You cannot, they literally have within the statute that a defendant cannot say that they were confused and they thought the minor was of age. It is strict liability and they are still responsible.
Ooh.
Right. The Florida statute. Now the snippet of the California statute that we just saw, we didn't see that. We didn't see that in the snippet that we just saw. And now we see the defense is quoting this case, People v. Hernandez, and they're saying this case supports the idea that if a defendant has some reasonable belief that they are having intercourse with someone who is of age, then it should be taken as a mistake of fact. Here's the thing, though. That case is from 1964.
Right.
And so I am willing to say, I'm willing to bet that there have been many, many cases addressing that issue since 1964. So I'm sure the defense attorneys just found a case that suited their argument, regardless of how old it is.
Right.
And they decided to go with that case, you know. However, I will say, it looks like California may need to tweak their statute because I don't see their statute saying what the Florida statute says.
Right now, and in New York, that statute doesn't even apply. I was looking it up. The mistake of age, it doesn't work here in New York. Not at all.
Not at all. That to be correct, Diva. The mistake of fact doesn't work in the state of New York either, which is why, like I said, I'm surprised to see that allegedly the California statute doesn't have a clause in there about that.
Right. And over here, it just says that, look, Section 2, it says that Hernandez was superseded by statute 26(1.5)(d) only regarding sex with a minor under the age of 14, and that is not applicable to the instant case. So is that more or less like what you were saying?
Okay, so what they're pretty much saying is that the case was overruled regarding, I shouldn't say overruled, but the case was addressed. It was distinguished regarding people under the age of 14. So I'm assuming that the state of California said strict liability for people under the age of 14, but they still haven't made that clear for people over 14. And his attorneys are arguing that because all these victims were allegedly over 14, then strict liability still does not apply. And I'm surprised at the state of California on this.
Right?
So yeah, I'm surprised.
That's crazy. Now, now the change. Now, did they wanted this changed in the verdict sheet? Is this what this is about? Because I was kind of confused. Is that what this means here? That it says the defense respectfully requests that the court amend the verdict sheet so that the choices read not guilty, guilty, and not proven, and proven. Because on
Right.
the verdict sheet, it only says guilty and not guilty.
Right. So they want to add choices. And quite frankly, that's going to make it more confusing because not guilty and guilty are sufficient. I don't know what they're going for with this not proven and proven. And I think that is just going to confuse the jurors.
Right. And that's what they want to be put in some of these questions, not proven, like with the bribery and stuff. And then it says at the end, it says, the rationale for such an amendment is obvious.
Yeah, here's a
The,
little hint. One of the first things that I was taught in my first year of law school is whenever you're writing anything to a judge, you don't say obvious and you don't say clearly. Because the minute that you're using the word obvious or you're using the word clearly, you know that that's because it's not obvious or it's not clear. If it was, you wouldn't be writing about it.
that's a good one. Oh, snap. Okay.
First day of legal writing class, Professor Long, he said you never
Okay.
use those words. He said no obvious, no
Oh,
clearly. Because if it was, we wouldn't be here.
wow. But that makes sense. That makes sense. That makes a lot of sense. And then it says that the defendant is presumed innocent. To require the jury to surrender that presumption to first consider guilt in order to go back to a consideration or whether the defendant is not guilty is confusing. May shift the burden of proof and denies the defendant
Oh,
the true presumption of innocence. Yeah,
I'm
girl,
confused
please.
by that whole paragraph.
Hello. Thank you.
They're talking about things being confusing. They are confusing. What?
Girl, please explain that to me because that made no sense at all. When I first, because I read this the other day, when I first, I was like, I was like, Miss Esquire has to help me out because Lord, they are confusing me, and
So
they want the jurors
that
to be more confused.
the only thing that could make sense to me here is if the current verdict sheet has guilty first and then not guilty second. And I guess what they are trying to argue is that being that their client is supposed to be innocent until proven guilty,
Right.
the option should be not guilty as your first option and then guilty as your second option. That is the only thing that I can make heads or tails of out of that paragraph.
Wow. That's funny. That is,
I mean,
but
and to
like you said,
argue,
they're doing their job.
I mean, yeah, I mean, but to argue this is a little bit honestly ridiculous, though. I mean,
Wow.
because to argue that the order of the words can
Right.
overcome a presumption of innocence. So if you put guilty or not guilty first, you're somehow defeating his presumption of innocence. That's really ridiculous. Honestly, that was just a
Weird.
waste of a paragraph.
That's so weird. Like you sound backwards. I don't know. It's just I read that and I was like, they're bugging out. What they're confusing me. Oh man. So that was that. And then the government responded. Let me see if this is the one. Okay, yes, I believe this is it. The government responded. Joshua David Ramos. Give me 1 second, guys. Because this boy, hold on one moment. Miss Esquire, would you like to take some questions in the moment from the chat if you can see them in the moment?
I will go ahead and do that. I will go ahead and scroll through and
yeah, I'm going through it with my son. Give me a moment, please. Thank you.
no problem. All right, so I'm just going to start having a little convo with you all while Diva handles business. Leocentric says, I'm 22 and I'm not even dating a 19-year-old. Oh, Leocentric ought to be 22 again. Shout out to you. And yes, right, as I said before, I think it's a little odd to me to be an 18-year-old who's even interested in someone who's 15 or 16, but hey, it is what it is. All right, I'm scrolling through looking for some questions. I see there's a conversation being had about state law. So Ruby, just to clarify for you, yes, each state has their own laws. That is true. But we do also have federal law. So federal law applies to the entire country, and then each state also has their own laws. All right, if you have any questions from me, so to Fat Boy, aka Splackavelli, yes, I am from Florida originally. I'm from Pembroke Pines. All right, if you have any questions for me, throw them in the chat. Let me also look at the chat on my cell phone because I think StreamYard is a little delayed. So let me get into the chat here. Put a little message to you guys. Drop your questions. Ruby said if you move, you have to learn new laws. Not necessarily, Ruby. Okay, so Take Rkelly would like to know, why would it matter if he meant to give herpes? He's charged with not disclosing it. So Take Rkelly, remember the statute that we looked at. So whenever you see a statute, right, and you see all these different portions of it, the different portions of the statute are called elements of the statute. And very often, if you are missing an element, you cannot prove that the person violated the statute. So if you go back to that statute, you see there are several elements. So yes, one of the elements is disclosure, but one of the elements is also intent. Intent is one of the elements in that statute. All righty, I am scrolling through the chat. Like I said, just plucking out questions. If you have any questions, let me know. And also, if you haven't had the chance to hit the thumbs up button, because I see there's quite a few people here, please do so. Diva works tirelessly on this channel. And I know you guys are enjoying the content that she's providing for you. All right, so I don't see any other questions thus far. So I'm going to assume that there are no questions right now, right? That's going to be my assumption. Alrighty, so being that none of you have questions at this time, let me ask you, because on this channel, you guys have been following this entire trial a lot more closely than really I've been able to. We've been delving into a bunch of different topics over on my channel. So let me get from everyone in the chat, what has been your sense of this trial? Do you think that the government has proved their case in this trial? Do you think that they've done their job and that Rkelly will be convicted? If you think the government has done their job and there's a conviction coming, let me see a Y in the chat. Take Rkelly says, I'm in Florida. I have a concealed carry. You guys know what that means. And there are only a handful of counties where pits are illegal. Okay, well.
I'm back, guys. Sorry. Thank you, Miss Esquire, for holding it down.
There's one question I'm going to answer in the meantime. Splackavelli says, Miss Esquire, do you believe that Polite and Kells are one and the same? Well, their charges are very similar, right? Polite doesn't have the enterprise charges,
Right.
but they have the same allegations regarding conduct with minors. And I will tell you what I do believe. I believe that if someone is truly a sex offender, it is recurring conduct. And I think that if you look at the history of both Polite and R. Kelly, you will find a string of people going years back, all accusing them of the same thing.
Interesting take, R. Kelly. Why do you
Hmm,
think they didn't prove a RICO?
that
That's
isn't.
interesting. She said what? You missed the beginning of that conversation, Miss Esquire. Hold
Oh,
on.
I maybe jumped in the middle of something.
Yeah, let me see what are we doing. I'm gonna take a couple of your questions. We're gonna take a couple of your questions, guys. I'm gonna go back as far as I can. Okay. Let's see what we got going on here. Okay. Mm, let's see. And it's up to that adult to not have sex or deal with a minor period. Okay. Well, if you had things that makes it harder to express yourself, but that's why I'm here. Okay, let's see. This was who's coming out to the Chicago. Some of the supporters will be out there. I know we ain't going out there. And my girls Tasha and the Truth will be out there. That's who'll be out there. Um, hello, Leo. Hey, Hattie. Newcomers in here. Hi, guys. Okay, let's see. What did she say here? Okay. She said women you're talking about were 12 to 17 at the time. Mentally and legally, they were kids. You're absolutely right. Tarsha said guilty 109 years. Oh gosh. Okay, let's see, guys. Any real questions going on? Um, Only a complete self-loathing pick-me-show would think a young woman wants gain by telling the world she has herpes and was subject to abuse and degradation. Yeah, make that make sense. Yeah, exactly. Okay, so no other questions, you guys? No other questions? Okay. All right. So we're going to continue. All right, let me take this off the screen. I'm waiting for Sly Fox and Next versus Truth and Tasha. Oh man, girls. My girls, my girls, you girls are fighters in here. I love you girls. You girls are such fighters. It's I wish that all the girls who are involved in this case, because we know certain girls know us, certain girls know us, certain girls know that we're here, but I wish all of them, plus more survivors of abuse, would hang out with us more. Don't worry, one day we'll get a gang for real up in here. We're at about 1,000 and change now. Somebody somewhere has been through it somehow, some way, you know, and it's a shame, that people like to just sweep things under the rug for the sake of the person. What about the sake of the community and the sake of the child that was violated or the person that was violated? Who cares if this person has a house on a hill with millions of dollars and he's the richest person in the community and helps out with this and helps out with that, and then he's a predator on the low and we're supposed to protect him because he does for the community? What did R. Kelly really do for our community except for give music? What did he really give back to his community? Let's think about this here. what did he really give back to his community? And I don't want to hear nothing about he spent money on a kid's funeral, he donated to this fund, he donated to that fund, he had a basketball game with a bunch of kids, and he was part of a parade, and that's not giving back to his community. That's not giving back to his community. Did he build shelters? Did he take people off the streets? Did he give people jobs? Did he do these things? Yeah, he gave people jobs. Yeah, he sure did. And he abused every single one of them that came in his camp. So what did he do for his community? That's a great question. Please leave your comments below if you have an answer to my question. Thank you. Thank you, thank you, thank you. I just had to get that out, Miss Esquire. You know, I get all over the place sometimes. You know me.
Oh no, you're good. You know, when I'm here, I'm just, I'm a silent until I'm needed.
My silent partner. All right, so now the government came back, okay, and they said that they respectfully submit their letter to correct its proposed supplement amended jury instructions regarding Racketeering Act 1 and Racketeering Act 3. In this letter dated September 19, 2021, the government inadvertently cited the current version of Illinois Criminal Statute 720-55-2 in Exhibits A and C, as opposed to the version of the statute that was in effect at the time of the charged offenses in Racketeering Acts 1 and 3. The government respectfully requests that the following statutory language be used for 5/5-2. So, Ms. Esquire, what does that mean? Because people out here are I understand what it means, but I want you to break this down because a lot of people are confused as to what happened. They're saying that the government made a mistake and that they were wrong to charge him with this.
So what they're saying is that the government accidentally used the current law as opposed to the law that was in effect at the time that these things allegedly occurred. Okay. So how can I explain that in a more
Yeah, fifth grade language, mommy.
So let's say, for example, today a law is passed that says it is illegal for you to go to ShopRite. But Diva went to ShopRite yesterday when it wasn't yet illegal for her to go to ShopRite. She shouldn't be arrested today for going to ShopRite because when she went to ShopRite yesterday, it wasn't illegal.
Right.
So what the defense attorneys are saying is we need to apply the law that was in effect when these things supposedly happened, not the law that is on the books now.
Got that? Good, guys. Take notes, please, por favor. If you need to take notes, please take notes, guys. Okay? Make sure you understand the words that are coming out of our mouths. We are trying to break this down in simple terms. I am not a lawyer. I am just learning law. I have my dear friend here who is law, who knows law, and who is here to educate us and correct us on the things that we might think, things that what they mean, but she's here to correct us and break it down because a lot of us are not smarter than fifth graders. So we need to break it down easy for you guys. So please take notes. Thank you. Some of us, need that. So now it's saying that the section, the 552 section provides in pertinent part that a person is legally accountable for the conduct of another, again, when the statute defining the offense makes him so accountable. Or C, either before or during the commission of an offense, and with the intent to promote or facilitate such commission, he solicits, aids, abets, agrees, or attempts to aid such other person in the planning or commission of the offense. However, a person is not so accountable unless the statute defining the offense provides otherwise. Can you please explain that?
Absolutely. Okay, so here's the breakdown.
Yes.
So
please.
a person is responsible, and by responsible, we mean a person could be prosecuted for the behavior of someone else when there is either a statute that says that person is responsible for the behavior of another person. So, for example, there is something in federal law called felony murder, right? And that is an example of a statute which specifically says, hey, you are responsible for someone else's behavior. So felony murder is if you intend to commit a felony with someone. So if Winston and Aaron decide that they are going to rob a bank, and they go in to rob the bank, and Aaron decides to shoot someone, Winston is not the person who shot someone, and Winston did not say, hey, shoot that person. But, sorry, Winston agreed to rob the bank. Well, if Aaron decides to shoot someone and that person dies, Winston is also responsible.
Right.
1 second, I'm joking.
Yeah, I just took a sip of water to myself. So
that's what the first part means. So the first part means, is there a law that says that you're responsible for the other person's behavior? Because then you are, right?
Right.
Then the second part says, if there is some conversation between the two people, either before or during whatever the action is. Oh, wait, you've gone too far. Go back up.
Oh, wait. Right. No, yeah, right. We were here, right here.
Yeah,
right
there in C, right. So if there is some sort of conversation between these people, either before or during whatever the offense is, and somehow that person is assisting the other person, then they can, by way of their assistance, also become accountable, right? So here's another example.
Right.
There's no specific law that says anything about what Aaron and Winston are doing. But Winston comes to Aaron and says, hey, Aaron, I want to rob a bank. I'm going to need your help. Can you get a van for me? I'm going to use it as the getaway van. Can you get me some masks? Can you get me some gloves? Right. And then Aaron proceeds to do all these things to assist in the robbing of the bank. Well, that can also be interpreted as Aaron aiding and abetting and being a part of the plan, which could make him also responsible for whatever happened during the commission of the bank robbery.
So, in other words, they're trying to say that in this statute, Rkelly should be accountable for the offense because he knew about it, as well as Demetrius Smith, right? But Demetrius Smith got immunity. Can Demetrius Smith, by any chance, could Demetrius Smith be recharged? Like, can he be charged even though he got immunity?
No, double jeopardy would attach. So the only thing that I could foresee, which, by the way, double jeopardy is your right to not be tried more than once for the same charges by the same charging agency. That's the part that a lot of people forget, because there were so many people up in arms over this R. Kelly trial and claiming that it was double jeopardy. And I was so highly disappointed in how
Yeah.
many people live in the United States of America and don't know the law in the country that they live in.
Right.
So it's, you cannot be charged twice by the same charging agency. So Demetrius Smith cannot be charged by the Eastern District of New York again. No. But could he be charged by the state of Illinois? Yeah. Could he be charged by the district in Illinois? Yeah. To
Ah.
my knowledge, his agreement is with the Eastern District of New York.
Right.
They can charge him again. That does not stop other agencies from charging him.
Thank you for clarifying that. I didn't know that. Thank you. Thank you. Thank you. Thank you. I was wondering about that because nothing for nothing, they need to grip him by his neck. Okay? They sure do. They sure do. In my eyes, he needs to be sitting next to R. Kelly. Okay? So that's just my humble opinion.
Right, right. You know, and so, I mean, pretty much the Illinois Criminal Code just says there's two ways that we can hold you responsible for the behavior of someone else.
Right.
First, we have a law that says you're responsible, or B, you assist the person to the point where you have to be responsible for their actions because you helped them commit the crime.
Right. So now, then it says in the second part, it says that, wait, I'm too fast on it. It says that, we read C. Right. Okay. So the other part, it says that part one, it says he is a victim of the offense committed, or the offense is so defined that his conduct was inevitably incident to its commission, or 3, before the commission of the offense. He terminates his effort to promote or facilitate such commission and does one of the following: wholly deprives his prior efforts of effectiveness in such commission, or gives timely warning to the proper law enforcement authorities, or otherwise makes proper effort to prevent the commission of the offense. Please break that down because I don't understand that.
Right. So what you just read are the exceptions.
Okay.
So the second portion where the Illinois Code says if you assist someone in their committing of this crime, you're responsible for what happens. They then are pretty much saying, we won't hold you responsible if. So we won't hold you responsible if you are the victim of this crime, which is fair.
Right.
We won't hold you responsible if somehow, the conduct that you committed, so whatever you did, right, was kind of incidental. So it wasn't necessarily something that was specifically for the commission of this crime, right? So it could have been, so back to my original Aaron and Winston argument, right? Let's say Aaron came to Winston and said, can I borrow your van? But, Winston doesn't really know what for or blah, blah, blah. That's kind of one of those exceptions, right? Because you're not a part of the crime. You don't know what it's for.
Right.
Then the last portion is if the person who is involved in the crime, before it gets to that point where the crime is actually happening, if they say, you know what, I don't want to be a part of this, and they go to the police or to law enforcement and say, hey, I know that this person is planning to rob a bank. He came to me for help. I did help him, but I've changed my mind and I don't want to be involved. That is also an exception. So these are the 3 ways that a person could be involved in a crime, but not be held responsible. First, they're a victim of it. Second, they did something they didn't really know was connected to it. Or third, they report it to the police before it happens.
So R. Kelly's definitely got hit. Neither one of them are getting away with that. Right? Because neither one of them went to the cops. Nobody in that bribery decided to say, well, listen, let me go to the cops. And when they did go to the cops, it was because he was subpoenaed.
Right. I haven't seen any actions that I think would fall under any of these exceptions. In
Right.
my, as you know, I say humble opinion. And I
Yes.
wanted to highlight Karen J said that the super fans were saying that Aaliyah's mom, the twins, and Geronda's friend were going to testify for the defense. What happened to them?
Oh
I
yeah.
find that to be interesting because with all of these arguments that, you know, nothing really happened with Aaliyah and there's no bad blood and blah 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 blah. I would think that they would be able to produce Barry Hankerson or
Yes.
Aaliyah's mother or somebody from Aaliyah's family to say that nothing happened.
Right. And they didn't. And that's crazy because the mother is hiding under a rock. That's what she's doing. Hiding under a rock. Barry Hankerson went on Oz and said that, yeah, he thinks that his sister was complicit with some shit. Allegedly. Yeah, no. And that poor baby girl was used. I just, a lot of these kids were being used, you know. I understand that the parents want their child to be in some type of stardom, and they push them. And, it's not like the parents want them to be in that type of situation. But for the ones that knew what was going on, shame on you. And I think they should all be charged. I really think that all of them should be charged for the ones that sat there and let Rkelly take advantage of their daughters like that and sons. If they knew, they should all be rotting in jail for some type of abuse of their own, abuse charges of their own. Like, I don't know, it's just so crazy because the women are women now. They're not kids anymore. And, statute of limitations by law with certain things. It's, it's crazy. What do you think?
Well, here's what I think. I think that the defense counsel, they are trying to do their job, right? Trying to get these jury instructions tweaked to some sort of favorable place for them. But ultimately, like I've been saying, it will be up to the jury. And I think with all of the evidence presented by the government, it's not going to be very likely the jury will be persuaded to give a full acquittal with all the evidence that they've seen.
Right. Wait, I think, is that the one? I think we were done. Yeah, I think we were done. We were done with all of that. So now we know that now there was closing arguments with the defense team. The prosecution was supposedly doing the closing arguments today. Did you get to hear about that, Miss Esquire?
Yes, I heard that closing arguments are in the works or in the process, and I plan on doing a final review of the trial once closing arguments are over. I think I'm just going to do a big marathon and just review the end of the trial and kind of have a conversation with everyone about what law we're seeing come into play here.
Nice. We will all be there for that. That is for sure. Yes. Guys, I'm going to say good night to Miss Esquire. Everyone say good night to Miss Esquire. We love you. Thank you for coming and for sharing your knowledge. As always, you are a pleasure to have and always welcome over here. And guys, if you would like to hit the Cash App for the guests, I pinned her Cash App to the chat. If you would like to Cash App me, the host, please do so. Donations are very welcome. Thank you, guys. Ms. Esquire, again, thank you for your time and your knowledge. I love you so much. Thank you so, so much.
Thank you. I love you too. And everyone in the chat, thank you for supporting Diva. You guys know that she's a good person and she's here with a pure heart. So I love that you guys are here supporting her and lifting her up.
Thank you, guys. So what I'm gonna do is I'm going to play a video of Miss Esquire. If you wanted to leave, that's fine. And I was going to read an article and then I'm gonna end the live from there. All right, guys. So you guys are gonna hang out with me a little bit longer? Yeah. Give me one in the chat. And please, guys, make sure you subscribe to Miss Esquire. Her channel is Empowered Esquire TV. I'm going to put her link in the chat. And she did a video, I think it was about 2 weeks ago, talking about Aaliyah and the Aaliyah portion, and also about the John Doe. So I'm gonna put the link in the chat, guys. Please go check it out and subscribe to her channel. Let me paste. Okay. All right. Thank you, guys. And like I said, if you would like to donate to her, her Cash App is pinned to the top of the chat. Her information is there. Thank you once again, guys. And thank you, Miss Esquire. Have a wonderful evening. Okay. All right, guys. That was awesome. We love Miss Esquire. We love you here, lady. Good night, sweetheart. And good night to anyone who is leaving. But I'm not finished with the commentary. I wanted to, during my live this afternoon, it was a pre-recorded live. And I had played a video with Jim DeRogatis on it. Unfortunately, I'm sorry there was no sound. So I'm going to play that interview all over again. All right, guys, is that cool with y'all? Give me one in the chat or thumbs up. All right. I'm going to play it. All right, and we're going to take a listen. I don't want to share it because I don't know if this channel might strike me. So I'm just going to share it with you guys from here.
Rkelly declined to take the witness stand today as his attorneys wrapped up their defense in his sex trafficking trial in New York.
Yeah, after 6 weeks of testimony from more than 45 witnesses, Kelly's lawyers rested their case in just a day and a half, and closing arguments began just after lunchtime. Reporter Jim DeRogatis has been covering Rkelly for more than 20 years now. He is joining us now to talk a little bit about today's developments in court. Hello to you.
Hello, both of you.
Okay, so let's.
We've gone into hyperdrive.
Yeah, here we go. I want to start with the decision by Rkelly not to testify in his own defense. Do we have any insight from his attorneys or any idea as to why that may have been, and perhaps any reaction during the trial from Rkelly that you can talk about?
No, the attorneys for both sides have not been talking in the media very much at all about their strategies. One can't help but think that when Kelly went on and was flamboyantly acting out on with Gayle King on CBS, that would not have been an effective display on the stand. We don't know what could he have possibly said. With 45 witnesses and a pattern of behavior that the prosecution sketched out lasting 30 years, it would have been very hard to defend himself.
Mm-hmm. The prosecution spent a month presenting their case. His team only took a couple of days. What did you hear from them, Jim, that stands out?
Well, the thing that's horrifying, and I think we're at a loss here, that there is no local media in Brooklyn at this trial, It was horrifying to hear a Chicago police officer who left the force after admitting guilt to forging checks talk about him giving security to Rkelly and other Chicago police officers working as Kelly's security when they were off duty. The defense presented 5 witnesses, all men, all of whom said they never saw any of the behavior that we heard about at great length during the prosecution's 19 days of testimony. There's a lot of people that are complicit here in either willfully not seeing this behavior or seeing it and never doing anything to aid the victims who stretch back to 1991.
It's so interesting. On the government side, we talked about these 45 witnesses that testified. It's hard to go through all of those, and there's so much to that testimony. If you could explain some of the ones that sort of you think will stand out to the jury, that the jury will really take into account.
Well, I think that all of those brave young men and women who told their stories, which were harrowing, I think it was the cumulative effort, Lourdes. I spoke to one of the top experts in the country for a piece I have in the New Yorker that went online today about the racketeering laws. And I think what the government was trying to do is say that Kelly ran this enterprise for 30 years while selling an incredible 100 million albums and directing many different associates, aides, employees over those 30 years to essentially round up victims for him. And I don't think that it was any one witness who made a difference. I think it was witness after witness after witness, the cumulative effect, because, they span abusive incidents from 1996 until that day in 2019 when Kelly was arrested in front of his luxury apartment at Trump Tower, Chicago. It's the whole 30 years that's come home to roost.
And that's the major difference between this racketeering trial in New York and Rkelly's trial that we had at the Cook County Courthouse here a bunch of years ago. That was one case, and this goes to a pattern of conduct.
One case limited by a judge, Judge Vincent Gaughn. This pattern was already well established and reported on by the Chicago Sun-Times since 2000, when Kelly was tried and acquitted in 2008. Chicago failed these many, many, many victims, 48 whose names I know, 22 mentioned in this federal trial. Chicago failed. The court systems failed. The press failed. The churches failed. The schools failed. I think that this tragedy is going to be one that's going to be examined by people for decades to come, and it has a lot to do with race.
All right, Jim DeRogatis, you've done such a wonderful job covering this case and this trial. We appreciate your time. We hope to have you again back soon.
Sure.
Okay, up next here.
Rkelly declined.
Well, guys, I just got an update. The government just put in another motion. I'm about to read it right now, guys. Let me upload it to my computer. The government just put in another motion, and I'm going to upload it to my computer, and I'm going to read it to you guys. Okay? All right, let me upload this. In the meantime, I'm going to play some music. All right. All right, guys. It's uploaded. Let me, okay. All right. Wow, look at that. We got some news that just came in. Let's see what happened here. Let me share my screen. Do you guys hear me good? Is my internet acting choppy, going in and out? Let me know. Give me a 1 in the chat. Yes, ma'am. A motion came in. Yes, ma'am. A letter of motion. Let me share it with you guys. I believe that's it there. Yes. Okay. All right. All right. Well, it's 5 pages long. Okay, so what I'm going to do is, because I'm going to close this live in a few minutes, so I'm going to let the read aloud do the reading for me. Okay? Is that cool with y'all? We're going to do this quickly.
United States Attorney, Eastern District of New York. EAG/NIS/MCM 271, Cadman Plaza East F, hashtag 2019, R00029 Brooklyn, New York, 11201. September 22nd, 2021. By ECF. Honorable and M. Donnelly, United States District Judge, United States District Court, Eastern District of New York, 225, Cadman Plaza East, Brooklyn, New York, 11201. United States v. Robert Sylvester Kelly, criminal docket number 19 to 286, S3, AMD. Dear Judge Donnelly, the government respectfully submits this letter in response to the defendant's request on September 22, 2021, that the court include in its jury charge instructions regarding witnesses who have testified pursuant to a grant of immunity and who have entered into a cooperation agreement with the government. The government does not oppose the defendant's requests that instructions on these topics be given to the jury. However, the government objects to the language proposed by the defendant and respectfully submits the.
You see what we were just talking about, me and Esquire, about the granting of the immunity? You see that it says that the court included in its jury charge instructions regarding witnesses who have testified pursuant to a grant of immunity and who have entered into a cooperation agreement with the government. So therefore, the government does not oppose the defendant's request that the instructions on these topics be given to the jury. However, the government objects to the language proposed by the defendant and respectfully submits, and let it continue.
That 2. Following proposed language, attached hereto as Exhibit A to this letter, in its instructions to the jury regarding these topics. Respectfully submitted. Jacqueline M. Cassillis, Acting United States Attorney. By /S/Elizabeth Nadia Shiata Maria Cruz Melendez, Assistant U.S. Attorney 718-254-6430. CC, Clerk of Court, AMD, by ECF, all defense counsel of record, by E3. Exhibit A, immunity and accomplice and cooperating witness testimony. You have heard the testimony of a witness, Demetrius Smith, who testified that he was involved in planning and carrying out certain crimes with the defendants and others. The government argues, as it is permitted to do, that it must take the witnesses as it finds them. It argues that only people who themselves take part in criminal activity have the knowledge required to show criminal behavior by others. For those very reasons, the law allows the use of accomplice and co-conspirator testimony. Indeed, it is the law in federal courts that the testimony of one accomplice or co-conspirator may be enough in itself for conviction, if the jury finds that the testimony establishes guilt beyond a reasonable doubt. You have also heard that Demetrius Smith testified under a grant of immunity from this court. What this means is that the testimony of the witness may not be used against him in any criminal case, except a prosecution for perjury, giving a false statement, or otherwise failing to comply with the immunity order of this court. You are instructed that the government is entitled to call.
Wait a minute. Y'all heard that? Did y'all hear that? Did y'all hear that? Me and Miss, we were just talking about this. So it says, you have also heard that Demetrius Smith testified under a grant of immunity from this court. What this means is that the testimony of the witness may not be used against him in any criminal case except a prosecution for perjury, giving a false statement, or otherwise failing to comply with the immunity order of this court. And it says that you are instructed that the government is entitled to call as a witness a person who has been granted immunity by order of this court. Let's continue. I'm getting myself some food, guys, so continue.
Call as a witness a person who has been granted immunity by order of this court, and that you may convict a defendant on the basis of such a witness testimony alone, if you find that the testimony proves the defendant guilty beyond a reasonable doubt. You have also heard testimony from one witness, Lewis, who testified pursuant to a cooperation agreement with the government after he pleaded guilty to a federal 4. Crime. There has been some discussion about this so-called cooperating witness in the summations of counsel, and about whether or not you should believe him. Cooperator testimony is of such a nature that it must be scrutinized with great care and viewed with particular caution when you decide how much of that testimony to believe. I have given you some general considerations on credibility, and I will not repeat them all here. Nor will I repeat all of the arguments made on both sides. However, let me say a few things that you may want to consider during your deliberations on the subject of cooperating witnesses, and those testifying pursuant to a grant of immunity. You should ask yourselves whether such witnesses would benefit more by lying or by telling the truth.
Oh.
Was their testimony made up in any way because they believed or hoped that they would somehow receive favorable treatment by testifying falsely?
Oh.
Or did they believe that their interests would be best served by testifying truthfully? If you believe that the witness was motivated by hopes of personal gain, was the motivation one that would cause him to lie, or was it one that would cause him to tell the truth? You have also heard testimony that Lewis has been promised that if he provides substantial assistance to the government and testifies truthfully, completely, and fully, the government will present to the sentencing court what is called a 5K 1.1 letter. The 5K 1.1 letter sets forth the cooperating witness's criminal acts, as well as the substantial assistance the witness has provided. I instruct you that the 5K 1.1 letter does not guarantee the cooperating witness a lower sentence. This is because the sentencing court may, but is not required to, take the 5K 1.1 letter into account when imposing sentence on the cooperating witness. The court has discretion whether or not a 5K 1.1 letter is written to 5. Impose any reasonable sentence the court deems appropriate up to the statutory maximum. The final determination as to the sentence to be imposed rests with the court, not with the government. In sum, you should look at all of the evidence in deciding what credence and what weight, if any, you will want to give to the accomplice and cooperating witnesses. Authority. Adapted from the charge in United States v. Price, 05, County Route 492, NGG, EDNY, United States v. Ashburn, number 11 CR 303, NGG, EDNY, and Modern Federal Jury Instructions Criminal P 7.01, 2021.
Okay. Okay. So these guys can't lie, or they will do their whole time, and Demetrius Smith could go to jail for perjury. So they better not be lying because they felt like they needed to lie because they felt like they had special treatment. Crazy, huh? We were just talking about that. Wow. And guess what else I got, guys? So, this that I have here is I got an alert about a transcript that was released from Daryl McDavid's hearing. Daryl McDavid had a hearing, guys. Yes, Robin, I agree. Revoke the immunity deals and lock them all up. Yep. Lock them all up and throw away the key, just like Rkelly. All of them. All of them. Exactly, Take. Exactly, Take. Yep. I agree with that. I agree. Missy's in here. Good night, Missy. I love you, baby. I hope you feel better, mama. So, I think I'm going to make another live, okay? I'll probably make one for tomorrow, and we can read Daryl McDavid's transcripts of his last hearing, which was on August 28th at 2019. Oh, wow. This was from 2019, guys, and they just released the transcript. Okay? Okay. It's 17 pages long. But we could find out what happened in this hearing, word for word. Uh-huh. What exactly is Daryl McDavid being charged for? And what did he say? What's his defense? We're going to find out what's Daryl McDavid's defense. What is he saying about the whole obstruction of justice? What's his side of things, right? All right. I'm definitely going to do that. I don't know if it switched on me. All right. Now, Sarah Kay, if you're in the building, mama, she had brought up to me about people screaming about the whole video thing and this, that, and the third, right? Now, I'm gonna let the read aloud, read again. Okay. Because I'm in the middle of eating. I didn't get to eat my dinner yet, guys. I'm eating all late. It's not good for you. Oh, yeah, I know. Okay. This is the hearing for Rkelly back in 2019 when he first got arrested in July. They had a hearing. We got the transcript of the hearing. And this is exactly what happened in this hearing. And Angel Cruel is the attorney for the government. Okay? We're going to read aloud.
One, two, three, four, five, six, seven, eight, nine, 5. Emmer Greenberg, thank you. The court, a proffer is not quite the same as testimony. Emmer Greenberg, right. But I'm guessing it will be lengthy. The court, so there won't be cross-examination. Let me ask this. How long do you think the proceeding will take? M.S. Krull, Your Honor, my argument is less than a half an hour long. The court, all right. Emmer Greenberg, I'll be seated. The court, very good. Emmer Greenberg, thank you. M.S. Krull, thank you, Your Honor. The court, Ms. Krull, you may proceed. M.S. Krull, the defendant, Robert Sylvester Kelly, should be detained pending his trial because, first, he is an extreme danger to the community, especially to minor girls.
I don't know what happened.
Girls. Second, he poses a serious risk of obstruction of justice in his current case, which also makes him a danger to the community. And third, he poses a serious risk of flight now that he's facing more serious charges with mandatory prison time. In this case, as you noted, Your Honor, detention is presumed under the Bail Reform Act because the defendant is. Case 1:19 CR 00566 1236. Charged with producing child pornography, among other things. So detention, Your Honor, is our starting point, and it's the defendant's burden to rebut that presumption of detention, which it simply cannot do. The defendant here is charged with incredibly serious crimes involving the sexual abuse of young teen girls, some as young as being in middle school at the time. Middle school. We're talking 7th and 8th grade girls. And it didn't happen once or twice. He sexually abused them hundreds of times before they turned 18. And that's just 2 of the victims. Between the Illinois State Court charges, the case in the Eastern District of New York, and the case right here in the Northern District of Illinois, there are 12 unique victims identified in those cases, and the vast majority of them are minors. And that's just the tip of the iceberg. Our investigation has identified many more girls who were sexually abused by the defendant, and our investigation is far from over. The evidence against the defendant is overwhelming. It includes hard evidence, direct evidence in the form of 3 videos showing this man, Rkelly, sexually abusing a young girl who was only 14 years old at the time.
Again, 3 videos. There's direct evidence in the form of 3 videos showing this man, Rkelly, abusing a young girl who was only 14 years old at the time. So again, the videos are in the Illinois federal case, not in New York. 3 videos in the Illinois case. Okay?
Time. These videos are extremely disturbing to watch, and they show defendant's sadomasochistic abuse of a 14-year-old girl. These videos also show defendant's particular sexual case 1:19 CR 0012337. Interest in young girls because he repeatedly tells the girl to refer to her body parts, specifically her genitalia, as being only 14 years old. And he does so in such a way that shows his sexual interest to girls that particular age. The girl's age is repeated at least 15 times on this video, these videos, including by the defendant's own mouth. Also on these videos, the defendant makes the girl call him daddy over and over again. And there is no question that it is the defendant on these videos. There are extreme close-ups of the defendant's face on these videos. 2 of the videos are filmed in very distinctive rooms at his former home. And the
2 of the videos have close-up of his distinctive face. Close-ups like, you're on candid camera.
victim in all 3 of these videos, she herself has testified under oath that it was Rkelly in all 3 videos sexually abusing her when she was 14 years old.
I'm going to back that up a little bit.
14 years old. Interest in young girls because 7. Interest in young girls because he repeatedly tells the girl to refer to her body parts, specifically her genitalia, as being only 14 years old. And he does so in such a way that shows his sexual interest to girls that particular age. The girl's age is repeated at least 15 times on this video, these videos, including by the defendant's own mouth. Also on these videos, the defendant makes the girl call him daddy over and over again. And there is no question that it is the defendant on these videos. There are extreme close-ups of the defendant's face on these videos. 2 of the videos are filmed in very distinctive rooms at his former home. And the victim in all 3 of these videos, she herself has testified under oath that it was Rkelly in all 3 videos sexually abusing her when she was 14 years old. There are at least 5 witnesses who will corroborate that victim. That evidence is overwhelming, Your Honor.
5 witnesses To corroborate Rashawn DeLand Fair's story, Wepa, in your face, she testified and said that was him and that was her. That's it, that's all.
Honor. The defendant repeatedly sexually abused a 14-year-old girl. He filmed it, and we have the videos to prove it. That weighs in favor of detention. But that's not all, Your Honor. In addition to the sexual abuse of at least 5 minors, several victims reported defendant's physical abuse in addition to the sexual abuse, hitting, slapping, punching, and spanking. And beyond the physical harm, there's the psychological harm that also must. Case 1:19 CRZ be considered in determining whether the defendant is a danger to the community. Both the Illinois and the New York indictments list examples of the defendant's manipulative and controlling behaviors that impose lasting harm to the victims in cases like this. And that's particularly so when the defendant is not in custody, because these victims fear him. All of this makes the defendant a further danger to the community. But what sets this case apart from so many others, and what makes the defendant even more of a danger to the community, is the defendant's extensive history of obstruction of justice, the threats, the intimidation, the witness tampering, the hush money payments, all outlined in count 5 of the indictment. And these aren't just mere arguments from a prosecutor. This is what the defendant is actually charged with. A grand jury found probable cause that the defendant obstructed justice in all of those ways.
A grand jury found probable cause that the defendant obstructed justice in all of those ways. Let me repeat that again. Hold up.
Be considered in determining whether the defendant is a danger to the community. Both the Illinois and the New York indictments list examples of the defendant's manipulative and controlling behaviors that impose lasting harm to the victims in cases like this. And that's particularly so when the defendant is not in custody, because these victims fear him. All of this makes the defendant a further danger to the community. But what sets this case apart from so many others, and what makes the defendant even more of a danger to the community, is the defendant's extensive history of obstruction of justice, the threats, the intimidation, the witness tampering, the hush money payments, all outlined in count 5 of the indictment. And these aren't just mere arguments from a prosecutor. This is what the defendant is actually charged with. A grand jury found probable cause that the defendant obstructed justice in all of those ways. This risk of obstruction is real. This risk is ongoing. And this risk of obstruction is heightened by the defendant's fame and power, which emboldens him to and gives him a unique ability to influence and intimidate witnesses and victims, and that continues to this day. Now, I expect the defense will argue that the defendant should be released because this conduct is old and. Case 1:19 CR 00567 document hashtag 40 filed July 20th, 19 page 8 of 40 page 1, 2, 3, 9. Dates back to the 1990s. First, that's factually just not true. Count 5 of the indictment, the conspiracy to obstruct justice, that count alleges conduct right up to the present day. And the New York indictment includes conduct in 2015 against a minor and in 2018 against an adult victim. So it's just wrong to say that these cases deal only with old conduct. But second, and perhaps more importantly, so what? There is no statute of limitations for producing child pornography and enticing a minor to engage in sexual activity. If the defendant was sexually attracted to middle school girls, to 8th grade girls in 1999, then he is still attracted to middle school girls and 8th grade girls right here in the present. He sexually assaulted those girls hundreds of times. Being sexually attracted to young girls is not something that you can just turn on and turn off like a light switch. It hasn't just magically gone away. It's who the defendant is. It's what he's been doing for most of his adult life, and that, Your Honor, makes him a danger today. The defendant's team has also argued that these new federal charges in Illinois and in New York are just for the same conduct that the defendant was acquitted of in 2008. Again, not true. There are 13 counts in the Illinois indictment and 5 counts in the New York indictment. That's 18 total counts. Only one of those 18 total counts is the case 1:19 CR 0010. Same as his state court trial in 2008. That means that the defendant is facing 17 new criminal counts that he has never faced before.
Not double jeopardy, because that means that the defendant is facing 17 new criminal counts that he has never faced before. Shall we continue?
Before. And what about that one count that does overlap with the old state case? That's count 1 of the Illinois indictment. The United States Department of Justice very deliberately charged count 1 of the indictment, even though the defendant was acquitted of state charges based on the same conduct, and that's because the defendant obstructed justice, and he ensured that the state trial was not a fair trial. He threatened and he intimidated minor one's family and other witnesses. He provided hush money payments, and he manipulated and controlled minor victims into lying about their abuse. Charging this conduct in the Illinois indictment sends a message that no one is above the law, not even a famous musician with lots of money and power. Now, the defendant will say that he's not a flight risk because he has showed up to all of his court hearings in the past, but the stakes have significantly changed. He is now for the very first time facing a mandatory minimum of 10 years in prison.
Hold up. I'm gonna I'm gonna rewind that a little bit, y'all. We need to hear that again.
Same as his state court trial in 2008. Same as his state court trial in 2008. That means that the defendant is facing 17 new criminal counts that he has never faced before. And what about that one count that does overlap with the old state case? That's count 1 of the Illinois indictment. The United States Department of Justice very deliberately charged count 1 of the indictment, even though the defendant was acquitted of state charges based on the same conduct, and that's because the defendant obstructed justice, and he ensured that the state trial was not a fair trial. He threatened and he intimidated minor one's family and other witnesses. He provided hush money payments, and he manipulated and controlled minor victims into lying about their abuse. Charging this conduct in the Illinois indictment sends a message that no one is above the law, not even a famous musician with lots of money and power. Now, the defendant will say that he's not a flight risk because he has showed up to all of his court hearings in the past, but the stakes have significantly changed. He is now for the very first time facing a mandatory minimum of 10 years imprisonment and up to a maximum of 195 years on the Illinois indictment alone. On top of that, New York has a possible sentence of up to 80 years. And that changes everything. Case 1:19 CR 00567 document 1-11. And before last Thursday, the defendant faced only the same court system at the same courthouse where he illegally obtained an acquittal by obstructing justice, and he likely thought that he would do it again. Now he has federal...
And he thought he would do it again. Psych. Sit your ass in jail and don't go nowhere.
Federal charges. He had little incentive to flee then. Now he does. The very obstruction of justice that saved him last time is charged in this new indictment. And so he knows it won't work this time because this time, his victims are cooperating with law enforcement.
This time, the victims are cooperating with law enforcement. Can we hear that again? Yes, 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 we can. And so he knows it won't work this time because this time his victims are cooperating. So that means Rashonda Landfair is testifying. Good night, Rkelly.
Enforcement. And that, Your Honor, is his incentive to flee. There are no release conditions that can mitigate these dangers. Electronic monitoring and home incarceration are just insufficient here.
It's not going to work.
Electronic monitoring does nothing about the obstruction of justice. It does nothing to prevent witness tampering.
Nothing.
Defendant could easily obstruct justice from the comfort of his own home,
Right
even
from
if
his
he has
house.
an ankle bracelet, but not so from the MCC, where his communications will be monitored. And on top of that, the defendant can entice girls to his own doorstep.
Wow.
He doesn't have to leave his home to do that, especially when he has assistants and other workers who enable him, as alleged in the New York racketeering charge. So electronic monitoring and home incarceration are insufficient to protect the public, to protect the victims, and to protect witnesses from defendant's obstruction of justice. Case 1:12. Finally, Your Honor, the defendant has already shown his intention to disrespect this.
Finally, Your Honor. and we're not talking about Auntie Ann. We're talking about our cousin, our uncle, actually our Uncle Lennon Weber. She said, finally, Your Honor.
This court by not being fully upfront with pretrial services. When pretrial services.
Oh, and he lied to pretrial services. How about that?
Services asked him about his prior marriages. Defendant conveniently left out his very first marriage in 19.
Conveniently. He conveniently left it out. Lord.
In 1994, and that's because that marriage was to a minor girl who was only 15 years old at the time, and the defendant was 27 years old.
Let's read
Finally,
that again.
Your Honor, the defendant has already shown his intention to disrespect this court by not being fully upfront with pretrial services. When pretrial services asked him about his prior marriages, defendant conveniently left out his very first marriage in 1994, and that's because that marriage was to a minor girl who was only 15 years old at the time, and the defendant was 27 years old. That marriage happened right here in the Northern District of Illinois, and the defendant knew that the girl was only 15 years old when he married her. Defendant was not upfront and truthful with pretrial services during his interview. Defendant mentioned only his second marriage, and he conveniently left out that first marriage because it incriminates him. He could have simply declined to answer that question if he didn't want to disclose it, but instead, he chose to lie and only talk about his second marriage. Emma Greenberg.
He chose to lie. He chose to lie.
Greenberg, Judge, I'm sorry. I don't mean to interrupt, but I'm going to object to that. And maybe I'll be a witness. He did decline to answer the question. I was there. The court, that I don't know. The record will be Amara Greenberg, I the court, okay. You've established the record. Case 1:19 1 2 3 4 13. Whether that's true or not, I don't know. MS Krull, all I know, Your Honor, is that's not reported in the pretrial services report that the government received that it was a declination to talk about his first marriage. Your Honor, the defendant is a danger to the community. He is a risk of flight. And he poses a serious risk of obstruction of justice. For all of the reasons that I've just laid out, the government respectfully requests that this court detain the defendant pending his trial here in the Northern District of Illinois, and then also for any transport to New York to face the charges there. Thank you.
Thank you, Ms. Krull, for letting us know again for like the 5th time we've talked about this. Thank you, thank you, thank you. And I'm going to take you guys out with this video. Thanks for hanging out with me. I love you guys. Here we go. Internet's acting funny again. Sorry about that, guys. My internet's acting up. It really is. I don't know what the heck is going on. I'm going to try that again, guys. Okay. Yep, my internet's acting up, guys. So I'm going to end this live. Thank you guys for coming. Please make sure you hit that like button on the way out. And if you are not subscribed to my channel, please subscribe. If you would like to join my membership, please join. I will be doing book club readings there. And that'll start soon enough, guys. Right after this trial, I'll go back to reading some books. We'll get into that. And then as we go along to, I believe in October, the trial should be starting for Rkelly in Chicago. So please make sure you subscribe, like and share, comment below in the comment section below in this video. Thank you, guys. And if you like to donate to the channel, my Cash App is Diva Divine Light. And if you don't have Cash App, I got Zelle. It's 347-664-9253, as well as PayPal. You can PayPal me at Diva Divine Light as well. Thank you guys for coming, and have a wonderful evening, y'all. Peace.